Our last one is legal realism, which is a catch-all category of sorts. Legal realism doesn't look to tradition, it doesn't look to written law, which would be positivism, and it doesn't look to divine or moral rights or any type of archetype high above all things. This one just simply says if the judge decided that you should go to jail because he was hungry that day or she had a bad lunch, then that's the reality of the situation. It can't be described anymore. My best example of this is a case from the United States Supreme Court. The court had a question which was, do we allow a state to take the life through capital punishment of an individual who committed a crime, a very serious or capital crime, when that individual was a minor? Such a question had never been decided before. Executing minors was indeed an unconstitutional approach because a minor lacks full mental capacity. She doesn't fully understand the consequences of her behavior, but what about an individual who becomes an adult during the time of incarceration, but was a minor when she committed the offense or the crime? Can the state execute such person? Well, the court decided that there wasn't any case precedent. It couldn't look back, so to speak. It couldn't use the historical approach. Furthermore, there was no written law. No written law existed. The United States Constitution, for instance, was silent about this issue. And indeed, the question is a constitutional one. Is it constitutionally permissible to take someone's life under such circumstances? The classic test is, what is the individual's right versus the right of the state? The other issue centered around whether any type of moral code existed through natural law. And the Supreme Court fell flat on this one. What guidance or rule could nature provide? Nothing. They looked then outside the law, so to speak. They reviewed how other developed countries had reviewed that same issue. Indeed, most countries did not execute individuals who were minors at the time they committed their crime, who then became adults while incarcerated. They also looked at studies done by psychologists, psychiatrists, and other scientists, which all said that when you're a minor, you don't have full capacity. You don't act like any adult individual. Indeed, the experts compared minority to groups who are mentally retarded, which may sound strange, but in comparison to how minors' brains develop, they said a minor's brain is not physically or psychologically capable of making full rational decisions. With that in mind, the court then used the school of legal realism to answer their issue. They reviewed, in other words, the social, the economic, the psychological, and other contextual aspects in order to make their decision. That decision ultimately was that it was wrong for states to exercise that much authority and take a person's life when indeed that person was a minor but became an adult later under incarceration. So, in summary, for Chapter 1, with the 4 basic schools of thought, I leave you with the question, what is yours? Where do you find yourself? And it can be a hybrid. Please email me if you wish to chat more about this important discussion.